Hold on, I'm trying to get my computer started up.
I'm sorry, I can't understand you saying.
Yeah, I'm trying to get my computer pulled up.
Okay. So that you will know where we are in the courtroom, opposing counsel is at counsel table. Your former spouse is standing about to be sworn in. Will you please raise your right hand, Mr. Greenberg?
Yeah, before, is there anybody else? Who else is in the courtroom?
Well, there's a court reporter and there's my court officer and my clerk. Those are the only and one litigant in the back of the courtroom.
Okay, so there's only one public witness. All right. So who are the court personnel?
It's not necessary for you to know their names. I have a court officer and my clerk. If you're going to participate, you need to raise your right hand to be sworn in. Please tell me when your hand is up.
Okay, go ahead.
Is your hand up?
It is.
Thank you, Mr. Court Officer, for the administer the oath.
You solemnly swear or affirm that the testimony you will provide this court, the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Greenberg?
Yes.
Thank you. You may put your hand down, and Ms. Gifford, you may have a seat. Mr. Greenberg, so that you will be aware, I'm going to have everybody speak in the microphones to make sure you can hear them. Counsel, these are your motions, are they not?
Yes, sir.
All right, for the record, will you please state your name?
John Walker, Kennedy Walker, or plaintiff Carly Gifford.
Okay, and how do you spell your name? I can't quite
M-A-H-E-R.
I pronounce that in my ears, but how do you pronounce it? Maher. Okay, forgive me.
There's a lot of pronunciation.
Okay, I can imagine. All right, you have two motions, but first of all, will you count off 1, 2, 3 to make certain Mr. Greenberg can hear you?
1, 2, 3, we have a motion to set and a motion to amend the petition.
All right, hold on just a second. Mr. Greenberg, can you hear Mr. Maher?
No. What did he say?
He counted off 1, 2, 3. Count off 1, 2, 3 one more time.
1, 2, 3.
Can you hear Mr. Maher?
Yeah, I heard that. Thanks.
Okay, thank you. Ms. Gifford, scoot up good and close to the microphone, and I want you to count off 1, 2, 3 to make certain he can hear you.
1, 2, 3.
Can you hear Ms. Gifford, Mr. Greenberg?
Yeah, go ahead.
Okay. If at any time you can't hear, please interrupt and let us know that, because I want you to hear what's going on, okay?
Okay, I appreciate that. That's the first for that. Go ahead. But now I still need to know who the court personnel are in the room.
I beg your pardon?
I need to know the names and employee ID numbers of the individuals that are in your courtroom today.
You'll have to call us later and get that information. We're going to proceed with our motions here. Your first motion, counsel, as I understand, is the motion to amend. Is that correct?
Yes, sir.
All right, I'll hear your argument, then I'll give Mr. Greenberg an opportunity to respond.
In that case, we call a motion to amend based on the court's ruling and request that maybe the means that we were went under to domesticate the foreign decree, which is a domestic relations foreign decree, that the method we were went under may only domesticate the child custody portions of that decree. So we amended it to include Section Rule Civil Procedure 3A.01 and Tennessee Code Annotated 24.104 to ensure that the non-domestic relations portions, non-custody portions of the order could be properly before the court on our motion that's pending in front of the court.
All right, and let me correct what I think is an error. I think in regards to the statute for registering a foreign judgment, and I think I had a mistake in my order. I think I put it at Chapter 24. I believe it's actually Chapter 26. So, and I believe when I read your motion, I think y'all used the correct code designation in your petition. But irrespective, I'll let you tell me how does that differ from the prior one? My recollection is you previously filed under 36.6.229 under UCCJEA to register a custody determination. My understanding that is currently pending in the Williamson County, Tennessee court. Is that your understanding?
No, Your Honor. What was
that was one of the things that in my order that I put down. I was concerned. I thought I understood that y'all were proceeding with the property portions, and so that's why I suggested that you didn't need to go under 229. You need to go under the other section that we just discussed. So whatever you're doing, y'all understand in regards to custody, as far as this court's concerned, needs to be dealt with in Williamson County, Tennessee. Does that make sense?
That's fine, Your Honor.
Okay, so I have a question.
Wait just a minute, Mr. Greenberg. I'm going to give you a chance to respond in just a second.
When this was filed, Mrs. Gifford was going to reside in Davidson County. There was properties that were in Davidson County that she was awarded that she was planning on moving in. Okay. And that's why it was filed here originally. And then Williamson County filed it. The child support office filed it there because when she was still began residing in Williamson County. And so that's where they put that.
Okay. All right. Now, in regards to the property issues, do I correctly understand that y'all have filed certified copies of both the trial court decision from the Superior Court of California, the Court of Appeals findings, and then the order from the Supreme Court denying the request for review? The certified copies of all three of those rulings have been filed with this court. Is that correct?
Yes, Your Honor. And just a short explanation of that, when they were originally filed with this court, the California courts stamped the certified on the back page of the last page of the order. And when we physically brought them here to have them entered, they did not scan that back page, not realizing that it was the stamps on the back side. So the transfer that shows on there that you can see on the online document is actually a reflection of what's on the back side of that page. So we did produce the original document to the court clerk originally for them to be entered. So we've now gone back and have corrected that error and copied that back page and put it in the record.
Okay. All right. So now we certainly have certified copies of those. And my understanding is you filed attached to your motion a copy of your proposed amendment. Is that correct?
Correct, Your Honor.
All right. Anything else you want to address on that before I let Mr. Greenberg respond?
Just with regard, there's really no prejudice to the defendant here who set the trial. The court took off that trial day and said amended to the proper proceedings. His objection is going to be the same to this motion under the change of statute as it was originally under the original pleadings, Your Honor. So there's no prejudice to him. Hasn't been heard. No decisions have been made. It's just for judicial economy. It seems best to continue under this rather than have the case removed and have to be reserved and reset. I would again say that the court has seen the difficulty we've had getting Mr. Greenberg into court to begin with. And he has also filed counter petitions in here. And I'm in one housing matter, I'm not clear if there's some kind of motion because it's listed under our case number for Robert Bullock. There's some type of motion or response that's due with regard to Mr. Robert Bullock. He's listed as a defendant on the screen outside with our case number.
All right. I'm uncertain. I'm not familiar with another litigant in this case, but I'll give Mr. Greenberg a chance to address that also. All right, counsel. Thank you. Mr. Greenberg, do you want to be heard in this matter?
Yeah, absolutely. So as far as housekeeping goes, it's unclear as to what is actually being attempted to be registered. They registered the child support, but that's erroneous in nature, but that's not for you to decide, I guess. But the decree contains the actual dissolution of our marriage as well as the property aspects. It has nothing to do with child support. It's separate. So I'm confused as to why you continue to say, or you have said, that this is not the domestication which determines how the children are supposed to be parenting time. The only thing that was decided.
Let me try to explain that, Mr. Greenberg. They're under the Uniform Child Custody Jurisdiction Enforcement Act, the UCCJEA, under 229, Section 229 of that statute. It allows you to register a foreign custody determination. When the court was reviewing the pleadings in this, it appeared, number one, I was aware, and I'm not sure how I became aware it, but I saw something indicating that something had occurred in Williamson County. It appears that there was some action going on, and I'm not familiar with the action, but Mr. Mayor has indicated that the child support services in Williamson County brought some action to deal with the child support there. I'm totally not familiar with that, and it's not before me, so I can't give you very good information. But you may check with the circuit or chancery court in Williamson County.
Right. No, I understand that, but
Okay.
but part of this decree in front of you is the dissolution of those children and my marriage and the property. It's all one and the same.
Right, and my understanding is it's all in the ruling of the Superior Trial Court in California.
Right, and that's what I'm here to challenge today.
Okay, and when counsel has filed certified copies, there's one order, and you're exactly correct. It deals with the dissolution of the marriage, division of assets, and deals with custody issues related. So you're correct; it's all in one order. What I understand is he's proceeding on is dealing with the division of property, and he's filed a motion to amend to proceed under a different statute that is isn't something special to divorce cases as the Section 29 is. It's a general statute about foreign decrees, and he's wanting to amend his pleading to cite that statute and rule. So I'll let you go on.
Okay, so that's fine, but there's no getting away from the fact that this order that you're trying to domesticate, whether it's just for property or for the actual dissolution or child support, is all fraud. So that needs to be challenged, as I've pled many times over, and this court has refused to acknowledge that I'm allowed to do that. Given that I've given you all kinds of statutes, and not statutes rather, but case law that indicates this is an accurate and well-intentioned manner of doing this, otherwise there would be no purpose of having this hearing. So with that, I mean, I'm ready to go ahead with my motion, or not my motion rather, but my assertions that I get to plead that there's fraud on the court, and I get to provide evidence of such, and then we get to throw out the order because it's all void and null.
I'm listening, so you tell me whatever you want to tell me about that.
Okay, so then we have to go back to the first document.
I'm listening.
Okay, so do you have the intent to appear?
I'm sorry, did you ask a question?
Yeah, do you have the intent to appear document?
Do I have what? I'm sorry, I can't make out your verbiage.
The intent to appear document, the one that I filed, I guess, on February 1st and February 3rd.
I have two motions on today. I don't have any other motion on. So,
Right.
If you want to argue against him amending his petition, this is your opportunity to do that, Mr. Greenberg.
Well, I'm arguing that he doesn't have a valid petition to amend.
All right, so tell me why that is.
Okay, so I'm asking you to bring up the document that describes exactly all of that.
I don't understand what you're saying. You want me to bring it up. That's what you're here for. If you have a response, if you file a response, you need to tell me about it and argue it.
Right, and I'm asking you to follow along with me, but you seem hesitant to do so.
I'm trying to hear what you've got to say, so you need to tell me why the court shouldn't allow him to amend this.
Because the judgment that he's trying to register is based on fraud.
Right, and what is the fraud that you're saying was perpetrated on the court?
Right, and so that's, again, if we go back to the intent to appear document, and every document subsequent, I have given you the case law that establishes how it is that this is a fraudulent ruling based on the actions of Julie Pavlov.
Let me say, Mr. Greenberg, if you want to stand on the pleadings you wanted to make any type of oral argument, I'm giving you that opportunity. But if you want to stand on what you filed, that's okay too.
No, so I need to pull up that document. But I mean, if you don't want to look at it, that's fine. I'll read it into the record.
Well, just tell me what your position is on it. You're telling me it's a fraud. Now, what occurred, my understanding is that you participated in the hearing in California. Is that correct?
Yes, I was allowed to participate for the first year, 2-3 years.
And do I understand they pointed a guardian ad litem to you?
Right, an adult based on perceived characteristics of a disability, which is in and of itself discrimination, but more importantly, it's a deprivation of my civil rights. And there's applicable or appropriate or whatever case law that I've supplied to this court that I'm going to read back to you now. That
And as I understand it, the court moved forward. The trial court moved forward with the ruling. You were represented by a guardian ad litem during at least part of that hearing.
Well, see now you've already stated erroneous comments, because in the actual documentation it says that this guy wasn't even my attorney, so I was left without an attorney. So hence I was further denied due process.
So who was the attorney that you hired?
No. I was pro per, but I wasn't allowed to represent myself.
You were representing yourself.
No, so again, I don't know why you're having trouble understanding the document that was sent to you. It clearly delineates what occurred.
I'm trying to, for the purpose of the record, I'm trying to make certain I understand it. But the judge proceeded in the case, and you appealed it to the California Court of Appeals. Is that correct?
No, we have gone too far at this point. You're not understanding.
I'm sorry?
You're not understanding what I'm saying.
Well, did you appeal the ruling of the trial court to the California Court of Appeals?
Eventually, but that has nothing to do with the sua sponte appointment of the guardian master, which made all the.
But the point of it, the reason I'm questioning that is that if the California Court of Appeals reviewed the procedure,
that has nothing to do with it. You're trying to equate. You have a false equivalency there. You're saying that basically that the Court of Appeals. I shouldn't even have to argue this, but I will. That the Court of Appeals can't issue an order based on fraud. The Supreme Court can't issue an order based on fraud. That's what you're saying, right?
But the Court of Appeals...
No buts. I'm asking you a specific, direct question.
They found that there was no fraud in this case, correct?
No, they did not. See, we've already had this discussion 12 times.
Did they not affirm what the trial judge did?
They affirmed the fraudulent ruling. Again, we keep going over this, but you keep denying the fact that they sua sponte appointed a guardian ad litem to me, and they weren't supposed to, which rendered the whole case fraud, whether it went to the appellate court or the Supreme Court. If they put the rubber stamp on a fraud order, it's still a fraud order. That putting the rubber stamp on the fraud order doesn't make it a valid order. Can you not read the case law that I sent you? Do you need me to read it to you?
And you, as I understand it, you asked for a review by the California Supreme Court, and they denied your request for a review. Isn't that true?
Yeah, what you're saying is true, that those procedures took place, but what you're not saying and not allowing to be said is that the order was fraud. And I have a right to challenge that the actual order was fraud, whether it was stamped approved by the Court of Appeals, whether it was stamped or not heard by the Supreme Court, is irrelevant. I have a right to challenge the validity of the order based upon the fraud upon the court. If fraud was perpetuated to obtain, I mean, I need a second to find the document so I can read this properly.
Okay.
I found what I need. Here we go. So this is the point. I requested back on February 13th, after getting and we've already rehashed that, notice of whatever it is. So, and then I requested that a hearing be held to once and for all dismiss all void orders. I further request that I receive proper service of the filing to dismiss the claims. And I said within 45 days. I then went on to tell you that I need due process. I need time to subpoena witnesses to appear to testify to the fraud. And then I explained how this case law applies to what you're trying to do today. Courts are construed by authority. They cannot go beyond that power delegated to them. If they act beyond that authority, and certainly in contravention of it, their judgments and orders are regarded as nullities. They are not voidable, but simply void. And this is even prior to reversal. So, do you understand that if Julie Palafox perpetuated fraud upon the court, it doesn't matter what the appellate court does. It doesn't matter what the Supreme Court does. They couldn't give it consideration. I have a right to come to you and tell you where the fraud was and how it occurred. Do you understand?
I understand that that's your position, yes.
No, that's not the position. That's the law of the land. Again, you're a public servant. You're there to apply these laws to facts.
All right, and let me make sure you understand, Mr. Greenberg. Today, opposing counsel is requesting to amend his pleadings. We're really not determining whether or not we're...
Right, and I'm telling you that it's inappropriate to amend any pleadings because you're giving consideration to something that's not even valid.
Today the court is simply considering whether he's allowed to amend his pleadings.
And I'm telling you he's not, based on fraud upon the court. I just read it to you. Courts are construed by authority.
So, and I understand what the arguments you're making, but I think probably you're making it the wrong time. We've got to have a hearing, and I'll give you another opportunity to make that argument. And I understand what your position is. But in regard to this issue under Tennessee law, the court is to allow him to liberally amend his pleadings. So,
right, but again, my objection is that you're giving consideration. You are giving consideration to orders that are void. You have to determine whether or not these orders are valid before he can amend them, or try to.
We determine that when we have a hearing on the registration. But today is just his motion to amend his.
Okay, well, yeah. So I mean, obviously, it's well documented that I have, said that this is not to happen under any circumstances. But I mean, if you're going to do whatever you're going to do.
I'm granting his motion to amend. The next issue is, counsel, as I understand it, you have a motion to set the case for hearing. Is that correct?
Yes, sir.
Okay. Madam Clerk, how long do you think this will take?
We don't have any testimony presented in our office of the legal argument based on the...
Come around the podium and make sure Mr. Greenberg.
Sorry, John. We don't have any, we don't believe we'll have any witnesses. We will simply be basing our arguments on legal arguments. So from my end, it will be maybe cross-examination of any witnesses that he may call.
Okay.
And I'll let the court know that he did send us some interrogatories asking questions about the 2017 trial proceedings. So he did send those to us yesterday.
Okay.
We'll respond to those as quickly as possible. Regarding which ones are relevant to this issue.
All right. What I'm anticipating is I'm going to give y'all I think probably everybody ought to be able to make the argument in half a day. But having said that,
I think it's probably going to take longer than that.
how long do you think it'll take, Mr. Greenberg?
Probably 2 days.
I'll give you a day, but that's the best I can do for you. So everybody needs to understand that if they have witnesses, we need to be ready to move forward.
Right, and so like, go ahead.
Pardon me, but we're going name that you had a question. You thought maybe Mr. Greenberg had filed a motion. Let's see if we can query. What's the name of that person?
Robert Bullock.
Do you know Mr. Robert Bullock, Mr. Greenberg?
Unfortunately, I do. Yes.
Who is that?
That was the fraudulently placed guardian litem upon adult sua sponte replacement for Gail Hickman. So.
Have you filed some motion involving that individual?
Yeah, I'm not sure exactly what it is that's being referenced, but.
That's my problem. I'm not familiar with it, and I only know when you file a motion when you put it on our docket, and then the clerk sends me a docket with the motion that you got. So if anything you file, please make certain that you're putting a hearing date on it. We hear these every Friday, but when you file it one week, it's heard new Friday.
Right. I understand.
You file those, touch base with the clerk and see what date they're going to be on. But counsel, I'm not familiar with any such motion, but if it gets on our docket, we'll be happy to hear it whenever everybody gets proper notice. Hold on just a second. I'm going to try to give you all a trial date.
Well, no. So I had a question before that, because I sent them discovery yesterday, and they have 30 days to do that. But based on that discovery and other discovery that I need, I'm thinking that it's going to be, depending on how quickly they get it back, and their answers, that's going to determine who and how long it's going to take for me to get additional discovery. So I can't guarantee that within 90 days that's going to be complete.
Okay, well, we'll check and see what days are available. What's our earliest date?
Earliest date would be in August 22nd, 23rd are available. And then you're looking at September 12th or 13th. I'm sorry, 13th. We were just
All right, September 13th, counsel, are you available on that day?
I am on September 13th.
All right, when will your discovery? You just got the discovery yesterday, is that correct?
Yes, sir.
So that was the 3rd, so August, September, so the 3rd. Do you intend to have the discovery in Mr. Greenberg's hands within the 30 days?
Yes, Your Honor. And it's just no request for documents or anything, just questions.
Okay. So no request for documents, but
Yeah, not yet. Not yet. So that's the first set. So again, you're trying to rush this through, and I have the right to obtain all evidence necessary to. I mean, I already have it, but you're not willing to acknowledge it. All the document or evidence necessary to establish that this is a null order that you're trying to domesticate. And again, I based on their responses and some other discovery that I have yet to send out, which will require another 30 days, I need at least 90 days from today to where it's even possible that I can present. I mean, the fact that I'm having to defend or even do this on a void judgment, so a court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. That's what you're trying to do. You're trying to take a void proceeding and make it valid. It is clear and well-established law that a void order can be challenged in any court. Are we in this court? It's properly before the court now, so I'm here to challenge it. And on many times over, you have told me that I cannot do that. There's no basis in law for you to tell me to do that.
or 28th, 29th.
November 8th. Can't hear you.
November 7th or 8th or November 28th, 29th.
7th or 8th or 28th, 29th.
Yeah, 28th and 29th is fine.
7th, I'm available either the 7th or the 8th. And I know the court, this matter's been pending for over a year.
Well, I do understand that.
Yes, you've been trying to commit fraud for at least a year.
Mr. Greenberg, if you'd be kind enough to let me finish. He said the 28th is fine, so we'll put it October the 28th.
October?
November.
Yeah, November.
Well, I don't want to wait that long. What were the dates, 8th and 9th?
7th and 8th.
7th and 8th. We'll put it on the 8th of November, Council.
Okay.
All right, so if you'll be kind enough to prepare the order. Mr. Greenberg, in regards to another matter, I know that you had filed an appeal in this case, and that matter was remanded over the issue of
Right.
cross.
Right, yeah, because...
The I'd like to do, Mr. Mayor, do you want to participate in that hearing on indigency?
Yes, sir. I'm asking, I think it was to determine whether he was a resident of the state of Tennessee.
Well, that's all kind of part of the same package. So that what I'm anticipating, that probably wouldn't take us more than 30 minutes or something one morning. So I'm going to try to do that on a morning. Can you be available, counsel, at about 8:15? If you want to participate remotely, as Mr. Greenberg is participating, you're welcome to do that.
That's fine, Your Honor.
Yeah, that's fine.
Well, let me check with Mr. Greenberg. Mr. Greenberg, some things that I need for you. I think you filled out an affidavit of indigency.
Right.
And so I'm going to travel with that affidavit. And then, Madam Clerk, give me a day. Do we have a Monday that...
Yeah, and so I can send you my driver's license and my mortgage statement and
I think a copy of your driver's license was attached to the information the Court of Appeals sent back to me. So bear with me just a
Okay.
second. Do you have a Monday? Go out on Monday after I'm back in town.
September 11th
Okay.
or September 18th.
September the 11th is a Monday morning. Can you be available on a Monday morning?
Yeah, that's no problem.
Counsel, so it makes it a little easier on you. On a Monday morning, I can actually hear you at 9 o'clock, not make you get up quite so early. Does that work for you?
That's fine.
And what did you say that day was?
It's September 11th, Monday.
Be September the 11th, and we will prepare an order setting that. Mr. Greenberg, I'm assuming you're still in Florida right now,
Yeah, I'm still on vacation.
so you'll be participating by telephone. And Mr. Mayor, you're welcome to participate. Just let us know first.
Yeah.
I'll put in there to both, and Ms. Gifford can participate by telephone too.
Why is she included in when determining whether or not I'm a resident of the state of Tennessee? That's unclear to me.
Because this is an action in in this lawsuit that you're part of, and she's part of the lawsuit, so she gets to participate in everything.
Okay, so did she? I have a question.
Let's get for just a second, Mr. Greenberg. Right now, we've been contacting you by calling you on your phone where you are.
Yes.
Okay? Because we're going to have multiple people on the line, we will have to send you information for you to call in to get on our phone bridge. And Mr. Mayor will have to do the same thing, and so will Ms. Gifford.
Okay.
When we send you the order, we'll send you the information, and you have to just punch in several numbers. Does that make sense?
Right. You know, I'm familiar with teleconferencing, and so that way I can also have members of the public join in on the call as well. Is that correct?
We're not going to have members of the public, but if you have a witness that you want to testify, it's perfectly okay for the witness. But we're not going to have this is a court proceeding, and they're not going to be broadcast unless the Supreme Court orders that they're broadcast.
Well, that's not actually true. These are supposed to be public hearings so that the public can see everything.
But they're in the court, supposed to be in the courtroom, and public can come into the courtroom and they're welcome to it. We have an open court here.
Right. But that extends virtually as well. But we don't need to make that argument. But I appreciate your candor. So what time did we decide for that hearing?
I beg your pardon?
September 11th at what, 9 o'clock or 8 o'clock?
September 11th at 9 o'clock.
9 a.m. And that's for the residency hearing.
That's for the indigency hearing.
Right, which is based on residency. Okay, yeah, indigency, fine.
Yeah. And let me, Mr. Greenberg, let me say, if you have any witnesses, it's okay for them to be on the phone bridge. We don't have a problem with that, okay?
Okay. But just not members of the public.
No, the public just can't come in to listen on the phone bridge because the phone bridge costs Metro money to do it that way. They're welcome to come into the courtroom.
Well, they're also welcome on the phone bridge and on Zoom. However, the hearing's being held.
You either have to do it my way or we don't get to do it. So I will send you an order.
Okay.
Mr. Mayor, I'm going to let you prepare an order consistent with the ruling on the amendment and setting.
Okay, I have a question about the time and date of Of the principal hearing. It was
Agreed on that.
November 8th, 2023.
November 8th, 2023, at 10 o'clock.
10 o'clock. Okay. And that is the actual hearing or trial.
All right, this will conclude our hearing in this matter. Mr. Greenberg, thank you for your participation, and at this time, you're welcome to terminate your telephone call. Thank you.
All right. See you later, guys. Take care.